Distinguished Global Expert Lecture Series 1, organized by the Global Academy of Law, Tech, Education and Research Galter in association with the International Law Tech Consortium and EST-FAB Cambridge, USA. We are honored to have one of the most distinguished experts in the field joining us today. Without further ado, I would first of all like to start by inviting our esteemed founder director of Galter, Professor Dr. M.K. Bhandari, to say a few words and welcome us all to this enlightening session. Over to you, sir.
Thank you, Dr. Prachi. It's indeed a great honor and privilege to launch the first series of our distinguished global expert lecture series. And our today's speaker is none other than the founding father, or I would say the pioneer of legal education reforms in India, Honorable Professor Upendra Baxi sir. In fact, he hardly needs any introduction, and all those who have done law uh, have learned from his work, his books, his teachings, and we are few fortunate to have Professor Bakshi with us as honorary member of Galter at this advanced age. His zeal, his enthusiasm, and his commitment to the legal education and legal philosophy is unparalleled. Uh, it's my added privilege to get inspiration and guidance from Sir. On behalf of all the members, I welcome Professor Upendra Bakshi sir for this inaugural webinar, and I request Prachi to formally introduce our distinguished guest. In fact, he hardly needs any introduction, but those who are from non-law background who are present in our this webinar, they would be definitely benefited and feel inspired to know about Professor Upendra Bakshi sir. Prachi.
Thank you so much, sir. Thank you so much, sir, for your kind words.
Let us clap. Let us show it once again. Let us show it once again.
Sir, can I do it once we introduce Upendra Bakshi, sir? So okay, it was pressed by mistake. Sorry,
okay.
Sir.
Okay. Sir, I think, yes.
Thank you so much, sir, for your inspiring
I think
words.
Sir has gone outside the room, I think,
yes, sir.
for a moment. Yeah. So meanwhile, we can just let him come back and take the seat.
Sure, sir.
Yeah. So, friends, especially those who have joined recently and those who have joined today but not member of Galter, we welcome all of you. And as you know that we are conducting every month, the monthly webinar, sir has come. And this is the global webinar in consultation and in association with the global institutions. Yes, please, over to you, Prachi.
Thank you so much, sir, for those wonderful opening remarks. And now it is my distinct honor to introduce the expert in the field of law, Honorable Professor Upendra Bakshi, sir. Honorable Professor Upendra Bakshi is a distinguished pioneer of legal education and an emeritus professor of law at both the universities of Warwick and Delhi. His academic journey spans decades, beginning with his law studies at University of Bombay and his doctorate in juristic sciences from UC Berkeley. Throughout his career, he has held notable positions including Vice Chancellor of Delhi University and South Gujarat University, and served as Honorary Director of Indian Law Institute, New Delhi. Professor Bakshi's groundbreaking work in areas such as constitutionalism, human rights, and social action litigation has made him a respected authority both at national and international level. His numerous publications and keynotes, along with the Padma Shri Award, speak to his immense contribution to the field. At the age of 85, Professor Baxi proves that age is just a number, continuing his active engagement in teaching and research. Sir, we are honored to have you with us. Please accept a small token of our gratitude, sir.
Oh, oh, great. Let us clap for him. Let us clap for him.
Thank you, indeed.
Nice gesture, Prachi.
Very nice. Very,
Yeah.
thank you.
Thank you, sir. Now, with great pleasure, I would now like to invite you, sir, for the lecture. Over to you, sir.
Thank you very much. Thank you, Prachi, for all your kind words. And for those who probably don't know India well, it is India tradition where the compere or the chief director of the program says that the speaker needs no introduction and it takes most of the time of the speaker. I'm very grateful to Prachi for being so pointedly brief. And I have mismanaged my life at times in many ways. So it is not necessary to narrate them all. But thank you indeed. Dr. Bandari and I go back a long way from Jodhpur days. And he is, in fact, although I'm a minor prophet, and I'll come to that in a minute, he is truly prophetic. He's looking at the future to be, or future which is already at the doorstep. It's no longer future, it belongs to the present generation in a big way. But to work on blockchain and rule of law, to work on artificial intelligence is not easy. I don't know where the word artificial intelligence came from. I'm researching that at the moment because the person who invented the future was, what was his name, from San Francisco, who wrote singularity. And singularity is near. And now he has come up with a new edition of, second edition of the book called Singularity is Nearer. And therefore, the word for artificial intelligence was singularity in earlier times. And none of his predictions have gone wrong. I'll get the name in a minute. So in a sense, we are, he's speaking, Dr. Bandra is speaking, and you all are Galterians are speaking to the future, not only of legal education, but future plus, whatever it may mean for the future generation. Whatever law and justice would mean for future generation is the part of your general conversation. But you do much more. I'm very grateful to be here. And I'm very grateful to welcome with Dr. Bandari and friends, all the new faces who will grace the Galter. And I hope, even as I speak, more people will join this venture, which is spectacular in many ways and international in scope. It's really breathtaking. So thank you again for inviting me. I do want to make a few noises, and I hope there'll be some time for discussion, but I'm not very sure what your time is. But thank you for coming in such good numbers from such different backgrounds and from different continents at this point of time. And in happy 75 years of the Constitution of India, greetings to all Galterians and those assembled here. And we celebrated the end of the 50th year of Keshwananda Bharati case, which ended on April 24 this year. This happens to be this week, I think, 7th or 8th happened to be death anniversary, 10th death anniversary of Jacques Derrida, a great French philosopher and thinker, who will surely, Professor Bandari, if he knew about you, deconstruct you. You're a great deconstructor, and he would relate your work to justice, which is yet to come. Its favorite was in French "Avanti," which meant yet to come. Everything is yet to come. Democracy is yet to come. Constitutionalism is yet to come. And peace, sadly, is yet to come in some parts of the world. So we will not go there, but Derrida made, and that's fundamental to my idea of social responsibility. Derrida had drawn our attention to the fact that responsibility is a meaningless word. Responsibility, have you heard of corporate social responsibility? And have you heard of Bhopal? And the great Kerala tragedy on cashew nuts, on inosylfen, and many parts of the world, there are similar stories of global risk society, which is worldwide spread. And victims are re-victimized in the process. Victims became generational victims of corporate perfidy and plunder. So Derrida spoke about white knights of responsibility. And the responsibility is not the word he wants. He wants instead a word with a hyphen, responsibility. Responsibility, ability to respond, not responsibility, on which there are plenty of theories. And I think I like that. It's another name for what I call socially responsible criticism or socially responsible citizenship. You develop an ability to respond to crisis. And your ability must be greater than the crisis to cope with it. And that's what Galterians are trying to do in various parts of the world, including India, where it's headquartered, and I wish you luck. But it seems to me that we live in India, I don't know whether that is the case everywhere, but it might be the case, under the tyranny or the theory of three prudences. Three prudences, which are those prudences? One is legisprudence. And in common law countries, in English countries, this is different from civilian law. We don't talk much about legisprudence, the dignity or the wisdom of the legislature. We only look at courts and not at statutes. And we think courts are superior, are oracles of law, are oracles of justice, they are called, to legislature. So that is legisprudence, which in Europe, it is studied very well ever since Bentham in 17th century. So by the first prudence is there. And jurisprudence stands for the first principles of law. First principles of law. And barring the bourgeois manners acquire, barring the present company, I've yet to meet a human being who knows all the first principles of law. We don't know what we're talking about when you talk about jurisprudence. Fortunately, some new beginnings have been made recently. And the third is what I call, and you now please have to be used. Prachi, you must introduce me to only one medium, and that is Baxi Moron. Baxi Moron is like oxymoron. Things that do not make any sense. I say it. So my Baxi-moron here for the purpose is demonstrance, wisdom of the people. And if you look at demonstrance, it is not a new concept for Indians, Indian constitutional law. If you look at any major judgment of the Supreme Court of India or High Court, they would say the word constitutional judicial review constitutional judicial review gets its strength and legitimacy and morality from the people. Every time there's election in India, people compete with each other naturally for power, but they compete also for what is in Sanskrit called Janta Janardhan. God is the people. Deification of people is democracy. Whatever people decide will be the right thing. Whether it is the right thing or not is open to discussion. But so idea of demonstrance is to respect the wisdom of the people and to worship them as the last authority in the world. People low lettering, idolatry, like people being deified. Demonstrance is deification, not merely hearing, listening to people, but demonstrance is not merely following of people, but demonstrance is the site of legitimation of judicial power, of the ideas of freedom, of fraternity, of equality, or what have you. So I specialize, after having done a lot of jurisprudence and doing some legisprudence, after having done some of both, I fancy demonstrance as people's movement and the law, people's movement and judicial review. So let me now start my topic, and I have 5 or 6 points to make. I hope I make them quickly, although a large number of notes here. I'm not going to that. First point is this. There are plenty of people who can tell you, not plenty, but some people who can tell you that how not to read a case. But nobody can tell you how to read a case or a statute or a judgment. I'm only on the case, that way. Why? Because Baxi 1, hurried reading is buried reading. In fact, hurried reading, I read it hurriedly, which means, in Baxi sense, it means I have not read it. You cannot read as you run, although people do. The modern generation had a great gift of short attention span. You can read 350 words. One of the retired attorney of the armed forces, actually Advocate General of the armed forces, came to me for some interview. His name is Captain Narendra Kumar. And Narendra Kumar said, I wish to take 10 interviews in a series called 80s and Going Strong. It's on the YouTube. And I said, then why 10 interviews? One will do. He said, no, the modern generation cannot hold for hour a conversation. They like snippets. So I take you 10 slides of you, 10 segments, and show them at different times. Each segment will consist of 5 minutes. They cannot sit for attend to things beyond 5 minutes. Therefore, they cannot read. Speed reading is no reading. Reading infinitely slowly, and this applies to writing as well, infinitely slowly is reading. Kumar Bhatt, a great Saivite in Kashmir of 12th century, great Pandit, Kashmiri Pandit, said, invented a notion which is of use everywhere, which is in Sanskrit, stands for the word Saradai Patak, which means in English, a compassionate reader. I don't have time to explain what compassion meant to him, what it means in Buddhism, but it's infinite, it is endless. It's not mercy, it's not empathy. Empathy, endless empathy. So it is thoroughly Pathak is one who is doing soulful reading, not soul-less reading. And soulless reading is no reading at all. What gives reading meaning is to put soul into the text, put soul, sensitivity of the soul, atma, as you call it in Sanskrit, ensoulment is reading. From this point of view, barring very few people, I must make a confession. Very few people read what the court says. Nobody has time to read judgments with court. Now, my first question to you all is, if law people don't read judgment, who will? You think management will read it? Economists will read it? And poets will read it? Jailers will read it? Who businessmen will read it? Multinational CEOs will read it? Nobody. Mr. Trump doesn't read judgment either. Nobody will read judgments. Excepting law students, they are addressed to wider audience, but primarily they are addressed to future law people. That they know what the law is. And judgments are written and they are published in no field of life, and reasons are given. Judgment is a unit. What's a judgment? A unit of reasoning and result. The result points north and result points south, there is no judgment. It's a unity between two things, reasoning and result or outcomes. So I think there's a problem in legal education and legal research. We are all very wise people in India. In fact, there are more wise people in India than there are cardinals in Rome. India is full of wisdom, wise people. Now, there's a feeling the wise people ought not to read. Now, that I don't understand, frankly. Wise people ought to read and write and remember. Anyway, so there is evidence to show that we have not read. I put the evidence before you. First, evidence, we are not readers, we are ratio hunters. We want to know what the judge decided in a case, court decided in a case. And the ratio hunters in all of us look at a single ratio. Now, I have a colleague called Professor Julia Stone in Sydney. I was privileged to teach jurisprudence with him and for 7 years. And Julius was a grand old gentleman full of vigor and full of jurisprudence. He wrote very big books on jurisprudence. But from 1947, we wrote Province and Function of Law. Till 1966, we wrote 3 volumes on law, including social dimensions of law and justice. Julia Stone had one mission, one target pointed mission. And that mission was to show that the case has not a single ratio, but as many ratios as you want. To say this is the ratio of a case is meaningless, according to Julius Stone. And he shows how. And he offers the famous analysis of Mr. Stevenson, a common law case where a Scot lady had a bottle of ginger beer, which had a decomposed remains of snail in it, and from which Lord Atkin asked the famous question, everybody is responsible for the acts of his neighbors, and who is my neighbor. And my neighbor in the industrial society is the producer. Strange idea of labor. They had what? Producer and consumer relationship. Although there is no privity of contract, there was some liability attached to it. I won't go there in the case. So you can judge according to facts that you like. Does this law apply to Scottish lady only or to all human beings? Does the law apply to decomposed snail in ginger beer bottle, or does it apply to automobiles without safety? This single judgment was read in multiple ways. So depending on the level of generalization of facts, you can generalize the ratio of the case. And despite the fact that Julia Stone wrote about it, and we all, most of us know about it, we still hunt for the ratio of the case. A reading of a case as a radio hunter is no reading. Now, I must hurry, I'm not finished my first point. My second point is we complain about prolixity of judgment. I make it short. Too verbose, too many pages, 1,000 pages, 2,000 pages. Now, we say it is too much to read. Question remains, who will read them? Question remains, why they're so long? Well, they are partly so long because a judgment as a discourse which says these were the arguments before us. These were the cases decided before us, before we came to judgment seat, precedent. And this is our reasoning, and this is the result. There are four things they are saying. So obviously, every judgment of the Supreme Court of India contains what my learned friend the petitioner said, what my learned friend the respondent said, what the amicus curiae said, arguments before the bench. My guess is maybe more than 1/4 is that stuff. More than 1/2 is precedence of prior courts, overseas courts, national courts, high courts, whatever. Now we just want the result. We are not litigants, we are not parties before the court, we are scholars of law, we say. We only need for result. This case mein ye hua, wo case mein ye hua. Sorry for speaking Hindi. This is what we want. This is a habit which grows with years. You skip and hop through the judgment. That is not reading. And two things we must know, we do not know. What are those two things? One is, how do lawyers think? And second is, how do judges think? We have not a clue as to what are the strategies of argumentation, because we skip the arguments before the court. That is decided the basis of argument. So I think this lack of not knowing how judges think and how lawyers think is a very major lack. And it remains. Now look at the National Judicial case, appointments case, very briefly. That case was all about National Judicial appointment. A law was passed. A constitutional amendment was passed. A constitutional amendment was ratified by a large number of states, some 20 or I forget exact number, but very, very great number. Why was this necessary? Because there were 3 judges' cases before that. The second judge's case, which was brought by the whole bar, Indian bar, before the Supreme Court, said that the executive shall not appoint justices. The Chief Justice shall have primacy. And there was no dispute. If you were to read the judgment, but most people don't read it. There was no dispute. The central government itself said, by an affidavit, the law secretary said, that out of 400 high court judges we appointed, 394 have been appointed according to the advice of the Chief Justice. So only 6 were appointed by the people. But in the classroom and the outside, we look learned by criticizing the court. And what do we say? The court should not make the law. The court should not do what it likes. The court should respect democracy. Don't we say that? And the constitutional amendment is written white. Don't we say that? And don't we look learned? Don't we look impressive? We are criticizing Supreme Court. It is pure nonsense. Because if out of 400 appointments, 394 were made according to the word of the Chief Justice of India. And the executive made only six appointments. I'm not saying that this is a government affidavit, state affidavit. But we have not read the case, we don't know. And yet, this is not socially responsible criticism. Collegium is bad. Judges appoint their own favorites, don't we say? But we look learned. Ultimately, they agreed on judicial collegium. Not only Chief Justice may be arbitrary, so let there be 3. And then the third judge's case, there will be 5. So there are 5 judges now, including Chief Justice. They may be arbitrary. Then what? I'll tell you what, I digress a bit and tell you. And Dr. Upendra would have this experience also, many of you would have this experience. And I was Vice Chancellor of Delhi University. The UGC required me to invite every qualified person. There was one post of biotechnology professor. 150 applied, who were all qualified according to UGC rules. I had to interview them all. And I made a rule that everybody will be given the same amount of time. So 30 minutes for everybody. So you can imagine how long it took to appoint one professor. 149 were not appointed. Only one out of 150, with only one post. All the 149 could legitimately say that you've acted arbitrarily. Then they do say, they said it to me, several of them, afterwards. Now, how does one decide? So some discretion in human affairs is unavoidable. You cannot eliminate discretion. You can hope it will be exercised bona fide. And the only bona fide way of exercising discretion is my rule. And everybody will be given the same time for interview. I cannot tell you whom to select, but I can tell you as a Vice Chancellor, I said to my colleagues, please, as chairman of the meeting, I will look at the watch for 30 minutes. Now, one person for 3 minutes, other for 15 minutes, other for 10 minutes. That's not fair interview. You say 20 minutes, I give 20 minutes. You say 10 minutes, I give 10 minutes. But then interview everybody the same, give them the same dignity as you give to the other fellow. Which we professors normally, we like to criticize others, so not giving dignity to others. And look very good. But you yourselves practice some different idea. So that apart. So there's further, I must hurry. Please stop me when I should stop or give me a time limit, and otherwise I'll go on. I'll take 10 minutes more and then to stop, and then the time for discussion. We'll do that.
Sir, you can
take
continue.
Yeah.
Sorry, sir. You can continue for next 15 minutes
Okay.
or even longer if you wish.
No.
Then we will definitely our
Next 15 minutes,
members.
more than enough. Thank you very much, sir.
Thank you, sir. Thank you, sir. Please continue.
This question, take the other option. Do we ever know? The other option is law minister and the government, the cabinet appoints the judges. We had that system for a long time. Before the collegium came. Now, I've not met any citizen of India who was better off under system A or system B. We complain about both the systems. We complained about committed judiciary, didn't we, in the emergency of 1975-76, which meant the Prime Minister appointed persons as judges, lawyers as judges, whom she felt finally can be approved. Her word was the last word, and the President signed it. We said the committed judiciary system was very bad. What's the option? Judges. Now you say collegium is very bad. What is the option? What is the option? You say nowhere in the world judges appoint their own. Pure nonsense. Everywhere judges are consulted in appointments in one way or the other. And everywhere their word counts. But let's go to legal reasons. Mr. Justice Jagdish Kher and his colleague, and all agreed, so all the 5 judges in the NJSC case gave extensive reasons. Before I come to reasons, I'll come to them very shortly. One more digression. There are 2 opinions in NJSC cases. 2, not 1. The one makes the second possible. What's the first opinion? All the 5 judges write on the convention that a judge should recuse. When should a judge recuse? And each had written a judgment on that. 5 judgments are given there. And they refuse to recuse. Why? Because their objection was that Mr. Chief Justice Kher should not sit on the bench. They didn't want him. But Mr. Palin Nariman and his lawyer didn't want him. They said, no, you cannot pick and choose judges as you want to. The only situation in which a recusal is justified is when there is a financial involvement. If you can say this judge should not sit on the case because the lawyer he argued for that case with a monetary involvement in that case situation, whether a constitutional list, LIS, list is a cause of action, where there's a list involving financial aspects, and if it is shown that the judge actually took money, fees from that, then the judges can recuse. But arguments were discussed in that 5 judgments, a very beautiful judgment, short judgment. When judges write short judgments, we don't read them. When they write long judgments, we don't read them. I don't know why, but that's how we do it. This recusal 5 judgment, Justice Chalameshwar goes so far as to say in his recusal judgment that it is our duty to decide the case without fear and favor. It is judicial duty under the Constitution, which is binding, against the convention of a lawyer mentioning a case before a judge saying you should not be on the bench. Justice Madan Law Court writes, well, I think they should give objective reasons for the decision to recuse. And these reasons can be reviewed by judiciary. Try another case as to whether they are accurate, they are justifiable reasons, not justifiable. So there are 5 opinions, and a law of recusal is being laid down. Nobody in India, just no one has read this. But Justice Care stayed in the case because of the decision. So recusal decision is NJSC 1. NJSC 2 is the decision on substance. Now I come to substance. Briefly, very briefly. What does it say? It says, Justice Care writes 500 pages, which no Indian has read. Correct me if I'm wrong. Write to me in the email saying you read it. And I was wrong. I don't mind it. But I don't think it will be correct. Justice Care says, number 1, there was never unlimited primacy of the Chief Justice. There was never unlimited primacy. There was limited primacy of the Chief Justice. The ultimate appointment was made by the President of India. And he is being made by President of India. And it's up to the President to follow the aid and advise the Prime Minister, Article 73 or something of the Constitution, or to decide on her own discussion. And the President may consult other people. It's written in the Constitution. President may consult as many people as he likes. It is written in 124 or something in your Constitution. So Justice Care, the court says there, it is the primacy, all right, but a primacy which is limited or shared with, and mind you, this language, shared with the President of India. And President of India is bound by primacy of the Chief Justice, but so is the Chief Justice bound by the primacy of the President. This is what they say. If it was absolute primacy, then of course he cannot interfere. So there is a constitutional hierarchy. Hierarchy, you know, the old English concept, hierarchy. 2 people share the power. President and the Chief Justice. Second, however, he says, Chief Justice's views ought to have greatest weight. Why? Because the government is the biggest litigant before the court. And that is true. You should have had title of the cases, just the title. So and so is the Union of India. Union of India makes the law, enforces the law. Union of India has all the powers, all the state. People, America says so and so versus people of California. That's our case. But maybe use the word state. So that's the second thing. And a litigant cannot appoint a judge as the principle of rule of law. Simple. Third, I can't go into it. I don't have time. I don't wish to go into it. He gives a number of reasons, including psychological and psychoanalytical literature on gratitude and repayment of gratitude. and how judges who feel obliged to the executive may want to decide in favor of the executive. And he says the Constitution and rule of law does not permit this kind of behavior. So I give you a glimpse of what the judgment says. There's a lot more happening. Justice Madan Lokur said, what does he say? He says, what is the alternative to committed judiciary? If committed judiciary is a wrong thing, bad thing, and we don't want it, what else can we do but to say Chief Justice and a collegium will appoint judges, recommend judges? There are other judges, Arun Goel and many others, who give the judgments. I won't go into that. But you have to read them. They slightly different from the Chief Justice, but in the end result, they conclude. So there is a rationale, and Justice Care says beautifully. And this one insight which I can't see one said in this case. He says the basic structure which the state cannot violate is a fragile foundation, not a robust bastion. These are the words I quoted there. A fragile foundation, not a robust, fragile foundation, not a fragile bastion, not a firm foundation. It may be founded on principles, it may be founded on provisions of the Constitution, be founded on ideas of constitutional judicial review, but the basic structure of the Constitution, which at least you cannot validly amend the Constitution until the Supreme Court agrees with you, Parliament. That amendment is all right. Where it is laid down in Keshwananda and since Keshwananda, that you cannot exercise, no organ of state under the Constitution can exercise unlimited power. All powers are limited under the Constitution. No power is unlimited. Legislative, executive, judicial. All power is superior within its jurisdiction. But no power is sovereign. Now, this is very important. Rule of law requires a constitution that all powers should be distributed under several institutions. Each power, each institution is supreme in the appointed judicial election commission, finance commission, UPSC, any executive, legislature, judiciary. Each institution is superior in its jurisdiction, but is not sovereign. So the government essentially is done by institutions which are superior but limited by the Constitution. And the burden and responsibility of the courts to judge whether a line has been crossed. And it's no secret, so I'll tell you, more amendments to the Constitution of India were passed after the basic structure doctrine was enunciated in 73. More than 50 amendments were passed since 1973. And the Supreme Court has sustained almost all of them. NJSC case, they invalidated. Maybe 49, maybe 3 or 4 more. So what is this trouble about basic structure all about? It is okayed amendments after amendment. Very substantial amendment. And it had during the emergency, height of emergency, 1976, in the very height of emergency, when no elections were in sight. It had declared 39th Amendment of the Constitution invalid 1 year after, 3 years after Krishna Bharati. So court has been doing its duty under some discipline. And a perfect answer to committed judiciary. And 50 chief justices have happened, as against 15 prime ministers, out of whom I wrote somewhere, only 3 were prime ministers for 15 years and plus. So you see the asymmetry between the highest executive and the highest judge. The Constitution permits this asymmetry, but the Constitution does not make somebody inferior and somebody sovereign. No. Constitution makes institutions under the Constitution to be superior, but never sovereign. Take it from me, I have no time. I'm the only mad lunatic who has read Keshavana Bharati 22 times in lifetime. You may ask me that better thing to do, but I'll come to that next time. But I would say, I stayed with, and Ram Jetmani was the only one person in the whole of Parliament to descend, and it only 2 minutes. And Ram pleaded, don't make this NJSC because you bringing back committed judiciary. And please remember the emergency. Nobody did. Everybody agreed, but the Supreme Court struck it down. And I think struck it down for right reason. There are 2 words that are used, and I'll end with this. Please remember that basic structure and essential features of the Constitution. Now, which is which? There is some confusion. But the confusion has been settled by judiciary bit by bit. For example, in a case called Nagaraj, several years after Krishna Bharati, they said the case does not apply only to the provisions of the Constitution, but it applies also to the principles laid down in the Constitution. Because provisions lay down the principles, like the principles of state policy, fundamental duties, fundamental rights. Provisions, there are no difference in provisions and principles of the Constitution. Certain provisions embody principles of Constitution. In Bombay, they said in some cases, although it does not involve amendment to the Constitution, but only sheer executive act, like Bombay, like executive act, there was to suspend the legislatures of the state and put them in what Indian Constitution calls precedence rule. They said precedent was justified in doing that. No violation of basic structure. So Supreme Court has been doing in Coelho case, recent one, they said unanimously that 9th schedule cannot be expanded eternally. So henceforth you will not amend the 9th schedule. You know what 9th schedule is? It's a terrible law. 9th schedule says notwithstanding anything in this constitution and notwithstanding any fundamental rights violation, the laws put in the 9th schedule shall be valid and no court shall question it. In 1980s, the Supreme Court said enough is enough. The 9th schedule is valid, but you shall not put any more statutes in it unless we agree with you. There's some oversight. So basic structure keeps on developing at the main point. Basic structure is not a static thing and developed by judicial discipline. But it's still difficult to say what is essential features. So I say another Baxi, but probably it makes sense. I don't know. With this, I more or less end. They say basic feature, basic structure is the power of judiciary to name essential features. We would rule that this is not an essential feature of what? Of the basic structure. So we have authority to decide whether a basic feature exists or not. If it exists, has it been violated by the facts given in this case? And even if it violated, what consequences follow? Not necessarily invalidity of the amendment. So I think I've said enough. The last thing, of course, Justice Kerr said that there is one thing, it's a fragile bastion. The court's under so many pressures from the market, from the state, from litigants, from lawyers, from media, from all kinds of people. Fragile bastion. Now just imagine the Supreme Court saying it a judgment. Not a robust foundation. Fragile bastion. The power at its most supreme moment, the power to declare a constitutional amendment void. Highest power is the greatest vulnerability. Please remember this word. Highest power is at the same moment the highest vulnerability. Vulnerable to what? Vulnerability to deprivation of that power or abuse of that power, for which you have to answer to the Constitution, to the rule of law, to jurisprudence. So this is, I will not go any further with this. This is where I'll sort of end my discourse, Dr. Bandari, and if there's time for any small questions or comments, I'll be grateful.
Thank you very much, sir. It has been one of the finest and great learning discourse for all of us. Since, sir, you have raised the issue of basic structure, which has been subject matter of my PhD research and later on the publication of this book from Delhi, I will share one copy with you when I come to Delhi and meet you. And this was the first book. One was written by Professor Lakshminath, and second one was this book, wherein I have dared humbly to disagree with the entire exercise of laying down the basic structure and especially the essential feature and especially the 9 judges summary which was written at the end. That is another topic we will discuss. Sir, if Prachi, can you permit me for 2 minutes?
Yeah.
Though I am too small to make any observations on your wonderful discourse. We all have learned a lot, and it has agitated our mental faculty to think further on how to read. You have rightly said that we should read like a compassionate reader and not a soulless reading. I fully agree with you, sir. Then you have also mentioned that we have to, how many of us read judgments in between the lines? Generally, we just go for ratio and that's all. So much things are, so much literature, so much philosophy and jurisprudence is there in any judgment of the highest court. Sir, we would also like to sometime listen from you the dissenting judgments, because as Charles Ivan Hughes, the former Chief Justice of USA, has rightly said that dissent in a court of last resort is an appeal to brooding spirit of law. Uh, Again, sir, regarding basic structure, you must have read the classic judgment of Justice Palekar, who said the basic structure is a twinkling star up above the Constitution. So anyway, it was really a great experience to listen to you for all of us. In fact, a great treat for all of us. Before we open the floor for 5 to 10 minutes discussion, uh, we don't have a capacity to raise any question to you, but certainly we can uh, engage in some discussions. I would invite Dr. Sindhu Bhaskar, who has joined from USA and one of the co-hosts. He is running a great organization which is working on the blockchain and fintech, and he has branches all over the world. Dr. Sindhu Bhaskar, please belatedly welcome our dear guest speaker and our member, not guest, our member. And as he rightly said, call me Baxi Moron. And the word, he is master in coining the new phrases. For us, he coined a term, Galterian, and we are really proud that he gave us a title, Galterians. Uh, Thank you, sir, for this creativity and your geniusness. Dr. Sindhu Bhaskar, you may please.
Thank you very much. Thank you very much, Professor Bhandari. And very grateful to Dr. Bakshi for gracing the occasion today and sharing his insights. Of course, I'm not any legal luminary, so I will not be able to speak anything about the legal matter because you people are doing great things and sharing, of course, about the objectivity of judges and all. Uh, One thing is there as compared to US and India, of course, judges are more impartial and more objective in India rather than US, because US has more committed judiciary. They may say anything because it all goes from president to president, and what we are seeing in Mr. Trump's cases. So it is a clear case of committed judiciary, but I will not like to say anything which can incite and excite judiciary to take action against me. So I am not trying to make a subjective assessment of anything. But as compared to countries, of course, it's a different situation. And moreover, in democracy, especially in India, what we feel that since it is democracy, so even we can abuse and misuse our freedom, including judiciary also. So we become all sorts of leaders, jurisprudence expert, and even medical experts, everything vis-a-vis our democratic freedom to cast our opinion on others. So I believe we are not that competent even in democracy until unless we have that knowledge. And of course, there are so many twists and turns and so many types of different pulls and pushes in society. It's very, very difficult to maintain that balance and create and give out and deliver an objective assessment and objective decision. So thank you very much once again. And I'm very, very grateful to Galter for giving us the occasion and opportunity to be part of such illustrious events. And we are very sure we'll be very much be part of future events also. And once again, thank you very much, Professor Baxi, and we'll sometime meet again, and we'd like to see how we can point more terms and terminologies to even JV arrangements also. Thank you very much. Have a nice evening, all of you.
Thank you, Dr. Sindhu Bhaskar. Now over to you, Prachi. We can have, sir, can we have 10 minutes of discussion,
sure.
if you permit? 10 minutes?
Sure.
Are you okay, sir? Because you have...
I'm okay.
Yeah, fine. Fine.
When I disintegrate, I'll let you know.
Thank you, sir. So now, Prachi, you can open the floor for discussion for 10 minutes and request all the members who are participating, please be brief. If you have any issue to be addressed by Professor Baxi, raise that issue precisely. Or if you have any comment to make, please make a short comment. Over to you, Prachi.
Thank you, sir. Thank you, Professor Baxi, for such a stimulating and insightful session. We are truly grateful for your presence and the valuable perspectives that you have shared with us. Also, Professor Bhandari and Dr. Sindhu Bhaskar, sir, for your expert views. Before we proceed further, I would just like to take a moment to highlight again something special that Professor Baxi has coined a term that perfectly embodies the spirit of our members, that is Galterians. While Professor Bhandari has already acknowledged this, I just wanted to emphasize how fitting this term is. So thank you once again, Baxi sir. I encourage all the Galter members to proudly use Galterians when referring to their connection with Galter. With that, I now officially open the floor for the discussion. I invite all the participants to share their thoughts or opinions on the topic that has been discussed by Professor Baxi. Over to all the participants now.
Please raise your hand quickly and unmute yourself, maybe unmute your webcam and participate. We want greater participation within available time. And we can please have a group photo, Prachi. Before that, request all members to switch on their webcam so that we can have the pleasure and honor of a screenshot with our distinguished expert. Yeah, please quickly, without wasting much time, quickly please raise, switch on your webcam. Please.
Okay. Okay, on the count of 3. 1, 2,
Excuse me, sir. Excuse me, sir. Is the video camera enabled for us? Because I'm not able to switch on the video. From the host, is it enabled?
Yes, sir. The setting has been enabled for all the participants.
We have to take 2. There are more participants. All cannot come in one frame.
Yes,
so we have
sir.
to take 2. Yeah. Please.
On the count of 3, 1, 2, and 3, please smile. Thank you. Sir, I see Dr. J.R. Sharma wishes to speak.
Okay. Yeah, please. Now it is open. You can keep
Yes.
your webcam on. No issue now. It's your choice. Yeah.
Yes. Good evening, Dr. Baxi, Professor Baxi sir, Professor Bhandari sir, giving me the opportunity to basically that Professor Baxi is a great thing, sir. We are having a very good lecture, very good insight from him. We are very glad and happy to that, sir, has actually discussed on a very important topic like a committed judiciary and as well as the judge made own judge. Sir, I would like to ask very simple and very this thing. Is there any via media in between way wherein it should be the judge should not be appointed by judge or by the collegium, or neither it should be committed judiciary? Is there any idea in between, sir, where we can have this idea ponder upon, sir? This question is to Professor Bhandari, sir, with a great humility. So I'm none to ask him; he's the authority, but still I want to have more insight.
You want from me to answer, or Professor Baxi? I think will be right person.
Yes, sir.
Professor Baxi would be the right person. Sir, can you give an alternative, a balancing kind of solution?
Well, the limited question was not of architecture. Limited question was of imagination. There was no imagination about the future architecture of the Constitution. Now, there is obviously a third and a fourth and a fifth way. I'm puzzled by the fact that Parliament never came back with a revised bill. What was the objection? The objection was, first, that nothing personal against the law minister. The court couldn't have any personal thing, but they took it that way. That's another matter. The court said the law minister shall not be the convener of the committee.
Yes.
Secondly, the law minister has no part because law minister is Ministry Union of India, the cabinet. So we can't have a convener. Secondly, they said you can have somebody, Chief Justice of India should be president, obviously. And they said that negatively, law minister can't convene the meeting. It can't play any role because they're litigant. Secondly, they said eminent persons which are provided by the law, the criteria of eminence are not defined or described. And several other things. So they could have read the judgment carefully and amended the law. They did not want to do that exercise. I don't know why. They have not done it so far. Interestingly, one of the parties in the parliamentary election had a whole page on the NJC case, the Indian National Congress. And they had said, if when we come to power in our manifesto, we'll talk with the justices, we'll hold discussion, and we'll find a way out of the system, the third way, by which justices will be satisfied, Constitution will be satisfied, but they did not make the government. So there are ways out, obviously. My own personal is that an advisory opinion can be sought by the government of India, where provision in the Constitution.
140.
The court is, and I suggested to the law minister in a meeting of so-called jurists, I was one of them. And I, in fact, formulated the questions. I don't have them with me now, but he did not name them, so we lost it. I can think about it. But essentially, the idea was that this is a partnership between judiciary and executive. It's not a committed judiciary or judges appointed judiciary. After all, the present system is a hierarchy, dual engine or whatever you call it, the hierarchy. That is, both government and the judiciary decide. They reiterate, they have to accept. When they don't reiterate, they withdraw the name. So my suggestion was that a presidential reference should be made. I still believe in it. If you're not going to legislate and you are concerned about it, the executive should or citizens should move for advisory opinion of the Supreme Court, asking the court what's the best way forward and formulating some questions which I had formulated that time. Anybody can formulate as to how collegium has worked to that, about dissatisfaction. And I think it is very easy to define eminent citizens. Justice Krishna Iyer wrote me a letter which I lost when I became the Vice Chancellor of South Gujarat University. I was very surprised Krishna writing my letter, and I know the tail is always in this, the string is always in the tail. So I looked below, and I found, but remember Bernard Shaw, he had wrote. And Bernard Shaw said, George Bernard Shaw is dramatist par excellence, and a wit, English wit, and George Bernard Shaw said, remember, the more eminent a person is, the more he or she has done to be ashamed of. Ashamed of. The more eminent you are, the more things you've done you are ashamed of. So he was complimenting him for being an eminent educationist, but he was also cursing the idea of eminence. So I think earlier I was asked when I was activist, I was asked by some ministers and judges precisely the same question. I said eminent persons would be, in my case, my example would be Mother Teresa and Baba Amte. They have nothing to do with law. I said, exactly that's the point. They know justice. They don't know law. So eminent, India is full of eminent persons. Only, yeah, sorry. So they can find eminent persons. They can define, describe.
Sir, I would request Government of India that the best eminent person today is Professor Upendra Baxi.
Oh no, governments don't like
No, I'm not flattering, sir. I am telling the right person who could be fit in the eminence.
There are many
May I
eminent
request?
persons. There are many eminent persons.
Yeah, sir. Yes.
They're spiritually eminent. They're able to classify them. Spiritually eminent, like his Holy Father is eminent person.
Yes. We
Now,
have Professor
Cardinal or Bishop.
Venkateshwarlu from UGC, Galterian Professor Venkateshwarlu. Can you raise? You are from. He's a joint secretary in University Grants Commission and our member also. Professor Venkateshwarlu, can you please join discussion?
Good morning to one and all, sir. Sir, regarding judicial appointments, so far there is no proper representation from deprived communities. Suppose if a National Judicial Service Commission comes, you can find some of the people from even deprived communities also. Why judiciary and government of India is not coming forward to conduct these kind of exams for upliftment of the deprived communities?
Thank you very much. Yes, it's a very important concern, not just a question or a comment, a national concern. Judiciary does not have a system of reservation, but they have de facto the system of in their day-to-day appointment. They have somebody from minority, somebody from scheduled caste, and so on. They have some women. It is very unsatisfactory, of course, but the difficulty is that number of judges is too small for a country like India. There is no enough 32, there are 33 judges of Supreme Court at the end of 75 years. And what's the population? 1.5 crores or something?
Yes, sir.
How can 33 people do justice to the masses of Indians? They cannot. Similarly, High Court, there are more than 600 or 700 judges in High Court. Now, you must have manpower planning. Sorry, I can't feminize it. The expression manpower planning, person power planning, probably. The idea of that per million or 10 million of population, you must have so many judges, so many police officers, so many collectors, so many the other officers. We must have plan, and there must be judicial person power planning. There's no use talking in 75 years of the Constitution of India as we're going to do in November. There is no use crying about delays and arrears in the court. We must talk about expansion, manpower planning of the by 2000, by Viksit Bharat they call it, by 100 years, next 25 years, there should be a plan of increasing the bench size in all courts, right up to district court and below district court, per X million of population. And why can't it be done? Earlier there was planning commission, now there is Niti Aayog, whatever. They have tomorrow they have something else. They can do an exercise in no time. How many politicians do we have compared with how many in the whole of country, compared with judges, or compared with policemen, compared with district judges, compared with how many women there are? The scandal has been studied. The Supreme Court had so far only 8 or 9 women. Why? It's by the collegium which came in the 80s. And judges appoint judges. Maybe in the high courts and district courts, there's a greater infusion. But when you think of Supreme Court, it is a story by itself. I've written on that. I've written all these things. But India is a beautiful country. You may write anything you like, or you may say anything you like, but nobody need read or listen. That's a different thing. But we can say. So we have said it. There should be greater representation, but possible only when, Professor, when there is greater number of judges. It makes sense. And the retirement age is absurd. They were fixed at the time when Indians did not live beyond 60, 65. Now all of us, look at me, they live up to 80, 80 plus. So I think it's not a bad thing to live long. I'm all for it. But point is not that. The point is the average age of death as longevity is increased. We live longer.
Thank you.
Now, there was a time when we died at 35. Shankara,
Yes.
great Shankara, died at 34.
Yes.
And now
Thank
we
you,
live-
sir. Thank you, sir. I think we have technology to assist us, technology to support us. AI and all these technologies, they can help us in mapping the entire functioning of judiciary, the requirement of the number of judges, vis-a-vis the pendency and the institution of cases. The technology can help us a lot. I think we can have one more question because it's already 6:30, near to 6:30. So, sir, we have retained sir for a long time. He joined 10 minutes before. So we can have one last question or observation. And
Could I
then,
ask?
yeah, Dr. Komal, Professor Komal, yes.
So
Please.
my question to Professor Upendra Baxi, sir, if we read this judgment carefully, the transparency was the main issue. So in fact, the government also mentioned that we wanted to bring in NJAC because we want to bring in, transparency. But Justice Charmeshwar at that time also mentioned that our collegium system is also not transparent, it is opaque.
Yeah.
So what's your take on this, sir? Because we
My
keep
take is-
hearing judges for judges and 110 families have been ruling judiciary in this country. So the transparency issue could never get resolved.
Transparency, I agree, but I think equally important is the question of limits of transparency. The transparency, up to a point, I would agree. But there are things we can't be transparent about. I gave the example of Delhi University professor in discipline, sciences, biotechnology, 150 applied, they all qualified. So 149 were not selected, Professor Kamal would argue that they're discriminated against. Quite rightly so, they feel unhappy about it. So this is the problem is there is a conflict between transparency and discussion. How do we solve the problem? How do we get around it? That is by accepting a fundamental idea that management of disappointments is a part of life. You cannot aspire for public offices and always say that if you are not X or Y is not appointed, the system is unjust. That is wrong. Now, having done our sums on this, that there are certain limits to transparency. That transparency cannot abrogate discussion. The task begins, what to say, of how to, first of all, expand the number of people who are in the institution. Secondly, provide for social justice and appointments. That is representative class. Now, the question of representation is very complex, I mean, if I may say so, because Parliament is supposed to be representative of the people. And what is the size of our parliament? 532. What is the size of French parliament? 1,000 odd. What is the size of the French compared to the size of India? So I think the problem of representation is shortly going to come before Parliament in a big way, because Mrs. Indira Gandhi limited states which overpopulated as a population planning measure. The population of the state has frozen to a certain date, 26 or something. 26 is coming now. Now there are states who are saying we control population very well and we should be rewarded instead of you raising the representation of people who have outbred themselves, who have no control of family planning, but the name. So there is a population and explosion and representation are related. And how will Parliament deal with it? I have no idea. So this is important. This is this relation between representation and, to use a word which is not appreciated very much, I'll use it, and justice. Not all representation is just, and not all underrepresentation is unjust.
Thank you. Sir, we have with us who is Professor A. Lakshminath, who has joined little late because of some issues. And he is also Galterian and very kind to me in person. I request Professor A. Lakshminath, who has been the Vice Chancellor, then Chancellor of 2-3 National Law Universities. Professor Lakshminath, sir, can you please unmute and join us? I think I saw him just now. Professor Lakshminath, sir, am I audible to you? Or you have left again? I request Professor Lakshminath, if he is present, to kindly unmute and say a few words. Okay, I think...
he is an old friend.
Yes, I know, sir.
And
no,
I call him
he joined me. I'll just give a call. Meanwhile, we can have one more question and then we will conclude. If he can join again, I will try to connect with him. We can have one more question.
No.
Professor Lakshminath sir. सर आपने ज्वाइन किया था तो आप दिख नहीं रहे. Because I called you, Professor Baxi wanted to meet you also online. So can you rejoin? Can you rejoin, sir? But because we are... Oh. So otherwise we are closing the session now. It is 6:30 more. So if you can join, it will be a great to listen to. We are for another 5 minutes, 5 to 7 minutes. We are here. We are now. So or you can speak on. I'll connect you on WhatsApp.
I'm not getting. What is the topic?
It was responsible criticism. How not to judge judges. You can speak to Professor Baxi via WhatsApp also. Yeah.
I don't know topic. I have not followed. Hello.
Judging the judges, socially responsible criticism was the topic. He has already delivered his wonderful lecture for about 1 hour, and now we are into the question answer session, and then we will conclude the session. So you can talk on. I'll switch on the. You can please speak on this.
I'll try.
No, you can speak on WhatsApp only.
Hello, Tanakya. How are you doing? Lord Tanakya.
Actually, he has got some technical issue, so he got out of the connection.
Maybe.
He's trying, but he says nobody's here to help me.
That's all right. That's all
Yeah,
right.
he's not
Yeah,
that
I'll
savvy.
talk with him. I'll talk
Yeah.
with him. I have his phone number.
Professor Lakshminath, you can, I think he's trying to join. Anyway, meanwhile, if it is possible, he can join, fine. Otherwise, Prachi, please invite our co-host for vote of thanks. Dr. Komal, you have raised your hands. You want to say something? Dr. Komal, you wanted to say something?
Subramaniam.
Then I have already
Okay,
asked my
fine.
question. So
Fine.
thank you so much.
Yeah.
So, Dr. Prachi,
Subram Rajkova is there, sir. Asking to raise some
Yeah.
questions.
you want to ask?
Subram Rajkova. Subram.
Subram, yeah, Subram, you want to raise a question? Please unmute yourself. You are on mute. We can't hear you. Okay, I think. Yeah, Professor Lakshminath, please unmute. He has joined. Can you, Professor Lakshminath, can you please unmute yourself? Professor Lakshminath, sir. Professor Lakshminath, sir, can you unmute yourself? Prachi? Yeah. Please unmute, sir. Sir, please unmute yourself. Please unmute yourself. Prachi, you are not here in the meeting? Sorry for interruption. There is some. Okay, Prachi has a electricity issue. She is trying to join on phone. Anyway, yeah. So meanwhile, I think Professor Lakshminath could not unmute and
I'll talk with him. But this is a very nice slogan for the people of India.
Yeah.
Unmute thyself.
Oh, unmute thyself. Very true, sir. Very true.
Very good. That
Yeah.
was the slogan
So-
of Galter.
Yes, yes. Thank you, sir. Thank you, sir. Now I request Alejandro Mendujano from Mexico, the country head of Government Blockchain Association and our partner in International Tech Law Consortium, to propose a vote of thanks along with Enrique Ajnar from Spain, Professor Enrique Ajnar. Yeah.
Okay, Professor Baxi, was a great dissertation. I really enjoy it, even though I'm not an attorney. But you mentioned so many things that we're facing in reality in these days, because we have witnesses that in so many countries have changed from the political side from right to left. And it's been a threatening thing, because now with these guys in power, we can see the same cases in Venezuela, Cuba, Nicaragua, and now in Mexico. They're trying to disappear the judges' independency. Now, for example, they are just proposing that people can elect the judges without the meritocracy that they need to be elected by. So they just want everyone to just elect. They're proposing, for example, that they're going to elect 40,000 judges in less than a year. How possibly can I define if a judge is correct one if I don't know anything about laws and his preparation and the meritocracy that they need to have, because you are the guys that lead the countries, because you are the ones that are intelligent enough and wise enough, because you are doctors in law. So being a doctorate in law means like that you need a lot of knowledge and study to develop a new law. So just imagine that we start picking any attorney which would not have the preparation and the career or the path of being a legal side. And it's very unfortunate that we're living that in so many countries, and that's putting democracy in risk. I know that we have in the past have many errors and mistakes in the right, but we need to define, as Don Tapscott mentioned, he's the CEO of Blockchain Research Institute of Canada, that we need to reconstruct democracy. We need to reconstruct the right side and make it more fair, so we can just include everyone.
Thank you.
So
Thank you.
it's very illuminating for me. Thank you, Professor Baxi.
Yeah, thank you for your words. Now, finally, the second vote of thanks from Professor Enric Ajnar. And
thanks, Professor. It has been a very illuminating masterclass by Professor Baxi. We are facing a fair amount of interference from the executive into the judiciary in Europe, particularly in Spain, where I live. And it might be an idea to invite Professor Baxi to share his enlightened views in this part of the world. Needless to say, I just want to thank Professor Baxi for his speech. I want to thank also on my personal name and also on behalf of the International Tech Law Consortium to the organizers, Galter, Professor Bandari, and Prachi for organizing all this and all the attendees. And I look forward to having more discussions like this in this context. Thank you very much.
So, Enric, when you invite Professor Baxi sir, he won't come alone. You also invite me, so I'll take care of him. So we both will come. We both will come. Okay. Thank you for your.
That's a deal. We will bring Alejandro as well, so that we meet the four of us together.
That would be great. So yeah. So finally, now it is time to conclude with this session. Thank you all who have joined and who have participated in deliberations, and our immense thanks and gratitude to respected Professor Upendra Baxi sir, who is one among us and who has been supporting us in more than one ways, and we shall continue to get his guidance, his blessings. With these words, now let us close with. Sir, can we close it now? I need your permission to close.
Thank you.
Thank you. So we close this today's global webinar series 1. We look forward to many more such illuminating, thought-provoking sessions from across the world. And we will also get the opportunity to listen to Professor Baxi on variety of issues reflecting the judiciary, law, legal philosophy, and society. Thank you very much. Namaskar, and have a pleasant evening.
Thank you all.
Thank you, sir. Thank you very much.
Thank you all. Thank you very much.